So the next important concept in interpretation of statute unit 1 is statute must be read as a whole in its context. So this has been asked for 10 marks. So what does it means? Principle. So when question arises as to meaning of a certain provision of a statute, it's not only legitimate but proper to read the provision in its context. So this is the principle of a statute must be read as a whole in its context, that the statute has to be always read in its context. So the question arises here, what do you mean by context? So the meaning of context. Context means the statute as a whole. First, the statute as a whole, then the previous state of the law, how the law was in its previous state, then other statutes in perimeteria. So perimeteria means the statutes which deal with the same subject matter. So for example, in CRPC we have Probation of the Offenders Act, and also we have a different act of a Probation of Offenders Act. So this Probation of Offender Act in CRPC and the separate act are statutes in perimeteria because they deal with the same subject matter. This has been asked separately also sometimes. So the next is the general scope of a statute and mischief it was intended to remedy. The mischief which the statute was intended to remedy. So all these 5 points constitutes the context of a statute. So the statute must be read as a whole in its context means we have to see all these 5 points. The statute as a whole, the previous state of the law, other statutes in perimeteria, the general scope of the statute, and the mischief the statute is intended to remedy. So this statement of rule is fully adopted by Supreme Court in India. The intention of legislature must be found by reading the statute as a whole. So this is referred to as an elementary rule by Viscount Simmons, compelling rule by Lord Somerville, and settled rule by B.K. Mukherjee. Case law. An illustrative case law is there, Attar Singh versus Inder Kumar. So in this case, the statute read as Section 13A Clause 2 of Punjab Rent Restriction Act 1949. It enabled a landlord to acquire possession of the rented land. So the landlord has already given his land for rent, but he wants to reoccupy it. Then this act said that he can reoccupy it for his own use, or if he is not occupying in that urban area any other rented land for business purpose, and he has given a sufficient cause to take that property back. So what happened is the owner, for his own use, he took back a rented property for his own use. So the tenant challenged it. So it was held that these 3 clauses, for own use, not occupying in urban area for business purpose, and for sufficient cause, should be read as a whole. So if these 3 are read as a whole, then the owner can occupy land only if he is taking for business purpose. Even it is for own use, but it should be for business purpose only. So this was held in this case. Next, mandatory and directory provisions. So this has been also repeatedly asked for 10 marks. What do you mean by mandatory provisions? First, so if the object of enactment will be defeated by holding it as a directory. So what happens in mandatory is the violation or omission of the statute is not allowed. If the statute is made, then we have to compulsorily follow it. Violation or omission is not allowed. If any kind of violation is done, then penalty is imposed. This is a mandatory operation of statute. The next is directory provisions. So what do you mean by directory provisions? If it is made mandatory, then serious inconvenience will be caused to innocent persons without furthering object. So in directory provisions, violation or omission of the statute is allowed. If the statute is enacted, then violation or omission is allowed. No penalty is imposed. So rules for determining whether the statute is directory or mandatory. First, the intention of the legislature is to be seen. Next, purpose behind the framing the statute. So whether they wanted to make it a mandatory or directory, the purpose has to be seen. The next, mandatory and permissive words. So if the statute reads as may, then it is usually directory. But if the statute utilizes the words must, shall, or should, then it is mandatory. Then statutes relating to judicial duties and proceedings. So statutory requirement related to practice and procedure in court. If it prejudices litigant's case, then it is mandatory. But if it does not prejudices the litigant's case, then it is directory. So if there is a statute or if there is a particular statute to be requirement to be followed as a practice and procedure in a court, then if that statute should be compulsorily followed if it prejudices the litigant's case. But if it is not prejudicing the litigant's case, then it is a directory. It is okay if we do not follow that procedure. Then for acts, statute relating to contracts and transfer. So all the statutes relating to contract and transfer are mandatory. So if there is a particular procedure to do a contract or transfer property, then it is mandatory and compulsorily be followed. Then statutes conferring power. So if there is a delegation of power by government, if a government is giving certain kind of power to certain person, then it is mandatory on that person to follow that power. But the way to express that power is a directory. So the person acquiring the power, he has to follow it as it is. But the way he is doing it, expressing that power, is a directory. Statute conferring private rights and benefits are mandatory. So if the statutes are conferring certain private rights and benefits on a person, then the statute is to be followed exactly. It is mandatory. Case law. H.V. Kamath versus Ahmed Ishaq. It was held that mandatory provision has to be strictly observed, whereas substantial compliance of a directory provision is enough. So the next concept is effect of expiry of a temporary statute. This has been asked as a short note. So meaning. So perpetual means no time fixed for expiry. If the statute is perpetual, means there is no time fixed for expiry. Unless it is repealed, the law will continue. But in a temporary statute, duration is fixed for a specified time, and after the specified time, the act will automatically expire. So effect of expiry of a temporary statute. What will happen if the temporary statute expires? It is given under section 6 of the General Clauses Act 1897. First, the effect on legal proceedings. So if there is a legal proceeding against a person during the activity of this temporary statute, but after the temporary statute expires, the legal proceeding against that person automatically terminates. He will not be held liable. Next, the notification, orders, rules, etc. that were given for a temporary statute, after its expiry, these notification orders also expire. Then expiry does not make a statute dead for all purpose. So the expiry of a temporary statute does not mean that for all the purpose the statute is dead. If any person is sentenced during a temporary statute for breach if he is convicted due to that temporary statute, but after that expiry of a statute, his sentence will continue. It will not expire. Then repeal by temporary statute. So if there is a previous already law existing, but after the temporary statute came, the previous law is repealed. But what will happen after the temporary statute expires? Does the previous law again revives? So it depends upon the construction of the previous act. So it depends upon the construction of the previous act. So to explain this, we have a case law, R versus Rogers. If a repealing section says that a repeal expires with the expiry of temporary statute, then previous act is revived. So when during the act itself, during enacting the temporary statute, it is said in the statute that the repealed act will automatically revive after the expiry of this temporary statute. Then the act will automatically revive. Next, codifying and consolidating statute. So what do you mean by codifying statute? So what happens is, on one subject matter, specific subject, a law is enacted. Then it is called a codifying statute. So one which codifies law, which purpose to state exhaustively whole of law upon a specific subject. So one particular subject, the law is totally codified. It is called codifying law. Unless ambiguous, court cannot go outside the letter of the law. Court has to exactly follow this codified statute. Example is Hindu Succession Act 1956. So we codified it. The next is consolidating statute. So what happens is, consolidating statute is the law is the same, but it has been scattered in a different statutes. So we gather all that statute and make one statute. It is called consolidating statute. Example is CRPC, IPC, etc. Next, enabling statute. So in enabling statute, the law which was once unlawful, we make it lawful. It is called enabling statute. Case law. Bidi Leaves and Tobacco Merchants Association versus State of Bombay. So by an enabling act, the legislature enables something to be done with conditions. It imposes certain conditions and makes it lawful. The next important concept, retrospective operation of statute. It has been asked for 10 marks. Meaning, so prospective means a law which is applicable only to future acts. So whenever a law is created, it is usually applicable to future events only. So if the law is applicable only to future events and acts, it is called prospective. But in certain cases, the law is applicable to past events also. So say for example, in a penal law, we add a certain statute punishing an act. And if that act is committed previously and we are going to punish it, then it is called retrospective. So we consider past acts also when the statute is created. But if it is applicable only to future, it is called prospective. General principles of retrospective operation of a statute. Power to make retrospective laws. So who can make these retrospective laws? Of course, Union Parliament and the state have the power to make retrospective laws. So they can totally obliterate an amending act and restore law as it was before amending. Next, statutes dealing with substantive rights. So what are these substantive laws, prospective or retrospective? Substantive law means the one which defines punishment. Like IPC is a substantive law because it defines, mentions the offense and defines punishment. It is a substantive law. So is a substantive law prospective or retrospective? So usually the substantive law are prospective. So they are only applied to future acts. In the future, if the person commits that act, then it constitutes an offense. But if he has done that act before the substantive law is created, then it is not considered to be an illegal act. Unless it is expressly enactment, there is an express enactment to make it a retrospective. So in that act itself, it is mentioned that a retrospective is activated in this. So if it mentioned that it is retrospective, then previous acts are also punished. Then statutes dealing with procedural laws like CRPC. So procedural laws are all retrospective. Even the previous acts are also followed with this procedure now. If this procedure is made, then all the previous procedures will be automatically made into new statute, follow new statute. Unless such construction is textually inadmissible, unless it is not inadmissible to do that. Then language not always decisive. So even if a present tense is used, then also it may be retrospective. It may be applicable to past events. So language is not always decisive. Case law. Hitendra Vishnu Thakur versus State of Maharashtra. So a statute which not only changes procedure but also creates new rights and liabilities is a prospective, unless expressly implied to be retrospective. So same as a substantive law, it is usually prospective, but unless an enactment says that it is retrospective, then it is done to be retrospective. So this concludes the first unit. Thanks for watching.